I'm Crystal Francis of WDSU TV of Channel 14, and I'm at the press conference where they're formally announcing the new head coach of the Hornets football team, Kermit Blunt.
Well, I think he's the best based on the recommendation from the search committee. The search committee did a really good job of vetting the candidates, and they sent his name up forward unanimously. And when you have that kind of support, that is very, very positive. And I did my background check, and talking to some of the presidents that he worked for, the number one thing that came back was character. And that's what I'm interested in. We want people around our students that will exemplify and model the behavior that we want our students to model. So, and with Coach Blunt, that he's a proven winner. And so I'm really, really pleased with his selection.
Well, you know, the first thing you want to do when you come in is you have to get to know the players first. You have to get to know the layout of the land. But the one thing that's always common at each and every university that you work at is, you know, academically making sure that our kids are sound, so we can move beyond that point and move into the next area of it. And then we'll get into evaluating our players to see where we need to add help. I'm not here to run anybody away. I'm here to enhance the program, and that's my number one priority.
The football team should win football games, and while we're winning, we have to produce outstanding students. Our students have to graduate. It's our responsibility to prepare them for life after football and life after their college experiences. But we're all in this business of intercollegiate athletics to win contests.
No, I'm just happy to be here. I am so happy and elated to be here. I'm happy to be a part of this, and I can put my hat back on now, and I can say that I'm a Hornet. And guess what? We're going to get that Hornet. We're going to sting some people with that Hornet.
On behalf of the students, we appreciate head coach Al Levan's outstanding services to the university, and we'd like to welcome new head coach Kermit Blunt.
Hi, I'm Steve Bursler. Again, taking a look at some recent rulings from Delaware courts involving Delaware corporate law, along with Francis Pileggi, member in charge of Eckert Siemens' Wilmington, Delaware office. Francis practices corporate and commercial law and writes the award-winning Delaware Corporate and Commercial Litigation blog at delawarelitigation.com. Francis, good to see you. Thanks for being here.
Thanks for having me, Steve.
A busy summer for courts in Delaware, dealing with numerous corporate law issues, and in early July, the Delaware Court of Chancery denied a status quo order. Now, first, as far as a status quo order is concerned, what are we really talking about here?
It's the same thing, really, as a preliminary injunction. You're asking the court to issue an order to stop someone from doing something, or in this case, to maintain the existing situation.
And so what are we talking about as far as the facts of this particular action are concerned?
In this particular case, the the goal was to make sure that a transaction was either going to be rescinded or the sale of a company would be stopped. It was a sale that involved installment payments. Mm-hmm. And the concern was, or the argument was, because the company that was sued was in poor financial condition, there was a risk that if you waited until the trial was over, and if the plaintiff won, that the defendant would not be able to pay and the plaintiff would not be able to collect. And so one of the issues was the financial condition of the defendant. And there are some situations where if the defendant is in such poor financial condition that a plaintiff would never be able to collect if the plaintiff won, the court will, under those circumstances, issue not a declaratory judgment, a status quo order.
Yeah. So the question becomes, when is a company's financial condition poor enough to satisfy the irreparable harm requirement for injunctive relief, right?
Right.
Are there other prerequisites for seeking a preliminary injunction in this type of situation?
Yes, there are three major requirements. One is that there be irreparable harm, which means that you can't be made whole by money. And in this situation, the court did not find that element to be satisfied. Another one is there's a reasonable probability of success on the merits, so you basically are guessing how the trial will end up. And the third is what's called a balance of equities, and the best way to describe that is there would be more harm if the order were not granted as opposed to granting it.
And so in this case, of course, the court denied the request for the status quo order because of the poor enough.
Right, there's a lack of irreparable harm.
Thank you, that's the word. Yeah. Well, if you're a practitioner, where would you find the guidelines to help steer you through these prerequisites?
Well, there are a couple of places. The opinion itself in this case has all the elements described. You can also go to various treatises, practice manuals that are available to describe.
The Court of Chancery, in an action against Lockheed Martin Corporation, recently bifurcated the case into two phases. Why did they do that, and what are the factors that are used in determining bifurcation under Delaware law?
Well, the situation in this case involved a bifurcation between liability and damages, and this was a very complicated case, and it might be best to answer your question by way of example. Because it was very complicated, let's say the trial would have lasted 6 weeks. And in this situation, there was not a lot of overlap between the evidence that was necessary to prove liability and the evidence that would be presented for damages. So the court determined that if the court just held a trial on the liability aspect first, if liability was not proved, then you wouldn't need to spend another 3 weeks in trial talking about damages.
I guess the fact that it was such a complicated case really helped to make this an easier decision to bifurcate.
Correct. If it was a one-day trial and you could do damages and liability in one day, then it wouldn't be much of an issue.
In addition, recently, the state Supreme Court in Delaware reversed a Court of Chancery decision interpreting a Brophy claim. Before we go any further with this case, explain a Brophy claim.
A Brophy claim is the state law version of insider trading. Most of the time when we talk about insider trading, it's federal law. But there's also a state law analog where you take confidential information and use it inappropriately.
So what was the specific claim in this case, and why did the Supreme Court reject the requirement of actual harm?
The claim in this case was that insiders in the company took confidential information and used it for their own benefit, which is a breach of the fiduciary duty that fiduciaries owe. And in the trial court, the Chancery Court found that because there was no damage to the corporation, that the claim could not proceed. The Delaware Supreme Court reversed and decided that in the context of breaching a fiduciary duty, there is no requirement that there be damages in order for a claim to prevail. Now, that doesn't mean you're going to get money, but there are other equitable remedies, the court said, that could be available even if damages to the corporation are not proven.
It seems as if the issue of actual harm or actual damages is a recurring theme in many of these corporate law decisions. Why do so many of these rulings turn on that?
Well, generally speaking, it's not enough to have liability, you have to have damages, because I use the example of passing a red light on a civil basis. If somebody passes a red light and it doesn't harm you, you don't have a basis to sue them because you haven't been injured. I'm talking about a private case, not a policeman stopping you.
Right.
But if someone passes a red light and they broadside you and they do serious damage to you and your car, then of course you have a claim against them.
Actual damages.
Actual damages. In this case, it's a little bit different. The court said because the breach of fiduciary duty is so important, we're going to allow the claim to go forward even if you can't prove money damages, because there might be some other equitable remedy that the court could impose.
These are, in many cases, very complicated cases, but interesting ones, and people can read more about them, as well as other issues, along with links to the decisions themselves, on the Delaware Corporate and Commercial Litigation blog, which is located at
DelawareLitigation.com.
Francis, as always, it's great to have you here.
Thank you so much.
I'm Steve Bursler. Thank you for watching.
this is Joe Jonas. You're in tune to 93.7 WSTW.
We got a listener on Facebook, Lacey Shrewsbury
Yep.
in Wilmington, and she brought something up that I was not familiar with, and she wanted to know about your panda obsession. I didn't know you had. Do you have a panda obsession?
I've never heard that
Is
one
this
before.
the first time you've heard it as well?
Lacey,
So
only made that up. Forget
thank you,
about it.
Lacey from Wilmington, for that question.
That was the first I've ever heard about my panda obsession. But I love pandas.
We just gave you a panda session.
I know.
Congratulations.
And now you have one.
Don't be
Everyone's being
shy
kind of
now.
shy.
You're all like, come on up. If you have a question, come on up. Come on up, dude. He's like, yeah, I got one.
I got one. I'll ask him from over here.
What's your name, buddy?
My name's Seth Michael Ayers. I have a question.
Sure.
Was it like hard, like leaving your brothers, like going solo?
Great question. It was good because my brothers were really supportive for me going into this solo project. So having their support and the fan support made it a lot easier.